Great. Thank you everyone for joining our week 3 of our summer series to build capacity for the Orange County Rapid Response Network. We're so excited that so many folks have been joining the last 2 trainings. For this week, we've invited Jacqueline Dan from the Orange County Public Defender's Office to talk about the criminal justice system and immigration consequences. These are some of the community agreements that we've talked about previously. We went over our introductions. And now to get started, I'd like to welcome Jacqueline Dan from the Public Defender's Office to talk about the criminal justice system. Jacqueline?
All right, thanks, Roberto. My name is Jacqueline. I go by she, her, hers. I live and work in Santa Ana, and I'm bringing this presentation to you not just in my capacity as an immigration attorney at the Orange County Public Defender, but also as like a whole person. So I've practiced immigration law in Orange County as an attorney for the past 10 years. And it's only in the past 10 months or so that I've actually worked as a criminal defense attorney focusing on defending non-citizen defendants in the criminal justice system against immigration consequences. But before we take that deep dive into how immigration consequences are triggered by the criminal justice system, in addition to the community agreements that we went over previously, throughout this kind of work, just based on the breakout sessions, it seems like many of you are no stranger to working with people in the criminal justice system. But for me, myself, there is always this constant interrogation of my own values, principles, biases, and how I approach the work and the people in it. And so there are some agreements that I think are helpful, internal to ourselves sometimes. And I think one of them is that we acknowledge that sometimes we might experience some inner conflict with this kind of work. For me personally, growing up in a Vietnamese community around the time I was 19, one of my friends who was my age in a family that was close to my family was murdered. And I remember that when they arrested someone for the crime, someone also of the same age, and he was sentenced to 10 years in prison. I remember at the time thinking that that was just not fair, considering that the person that I knew, their life had ended. But over the years, especially with the amount of time that passed, especially between the ages of 19, 20, 29, 30, I realized that no amount of time can bring back that person or change what happened. And then after a while, it stops making sense to me personally, how additional time beyond that and taking away someone's freedom for that amount of time, how much more time does someone need to really learn from what happened in that experience. And especially once I started with working with people who had been incarcerated, just getting to know them and what happened in their own lives and what was taken from them has really changed how I approach that issue. So that's something that we all might struggle with on some level. It's something that might change over time, but I think that it's great that all of us are here in this space and are committed to doing the work on behalf of people who are affected by the criminal justice system. Some words of wisdom from Judy Clark. Some of you may know her as the defense attorney for many people in federal death penalty cases. Several things that she said over the years that have resonated with me in particular. First is that a defendant is more than the worst thing he or she has done. I feel like that's really important in terms of my approach to working with people impacted by the criminal justice system. And then the idea that we stand between the power of the state and the individual. To me, it has been really meaningful to work with people in the criminal justice system, especially when you approach that person as worth your unconditional support no matter what they have done, that it's not something that they have to downplay or explain away for you to support them and find them worthy. And I think that that is something that has really helped carry me through the work, and to the extent that it is helpful to share it here, I went ahead and did that. So next slide. Okay, so what is crimmigration? So crimmigration, I can read this to you, but it's basically the intersection of the criminal justice system and the immigration enforcement system. Basically, there are a lot of changes in the law over the years to make immigration enforcement kind of align with basically the criminal justice system, and where they intersect to further not only criminalize people, but also like forcibly detain them, and then also deport them from the country. And so basically, like, there are increasingly more and more consequences for people who are not US citizens in the criminal justice system, as federal law and criminal law in the states align to basically create consequences for people here in the United States who are not full-fledged US citizens. Sanctuary policies, which are basically policies that the Rapid Response Network support, and that really arose when the United States was especially detaining, deporting, or expelling asylum seekers from Central America who are routinely being denied status. Sanctuary policies seek to limit or end that type of collaboration. And it's something that I'm going to get into further detail on in the later slides. All right, next slide. Okay, so basically the importance of understanding crimmigration is that 75% of all immigration detentions in Orange County come from entanglements or interactions with the local criminal justice system. So that's people who get arrested by local police for things like allegedly vandalism or driving without a license. Those are all things that funnel people into the criminal justice system, where increasingly we see law enforcement officials fighting to be able to turn people over to ICE. So in order to really stop immigration enforcement, we really need to understand how the criminal justice system funnels people into the immigration enforcement system. All right, next slide. Okay, so this is very specific to the Orange County criminal justice system. I realize some of you are not working specifically in Orange County, but the Orange County criminal justice system as a state or local law enforcement system hopefully is going to be applicable to many of the rest of you. And it's also important to note that this is not the federal criminal justice system, which is very different. But overwhelmingly, when people talk about the criminal justice system, or day-to-day wise, when people have run-ins with the criminal justice system, we're talking about local law enforcement and the local county criminal justice system. Next slide. Okay, so who are the players in the criminal justice system? It can be a little confusing, but as much as the gray bubbles tend to work together to funnel people through the criminal justice system, through the worst consequences of the criminal justice system and towards ICE, they are actually supposed to be distinct entities and operate separately. And so the first point of contact in the criminal justice system is going to be with a bubble that I've named policing and corrections. So that's basically the police departments, which are generally organized by city. So like the Santa Ana Police Department, the Garden Grove Police Department, the Westminster Police Department, the Irvine Police Department. And then also beyond city law enforcement, there is county law enforcement, which is the sheriffs. So the sheriffs conduct policing operations in all municipalities that do not have their own police department. So it's generally the smaller ones. And then they also operate our county jails. Okay, so when people call the police, whether they call 911 for an emergency or they contact the police department outside of an emergency situation, it's the police or the sheriffs, depending on the area that the crime happens, who will be the first responders on the ground and start investigating what happened, and then decide whether to identify someone as a perpetrator, that's generally what they use, or suspect in terms of someone who is suspected of breaking the law. At that point, they have several options. They can give the person a citation or a ticket, and then later tell them to show up in court. Or they can also, instead of just giving them a citation and releasing them on their own recognizance, they can also arrest that person and book them into the jails. Okay, and PARS is another thing that we're not really going to get into in this particular presentation, but that's just to give you a general overview, because there are some alternatives to just arresting someone and throwing them in jail. Now, the next bubble is the prosecution. Okay, so when we talk about the prosecutor, it's basically the agency that takes the reports from law enforcement, so from the police or the sheriffs, and then they decide whether a formal criminal case in the courts is going to be initiated against the suspect. Okay, so the way that that happens is they take those investigative reports and information, and they decide whether to file a formal charge in court, basically like a misdemeanor or felony or infraction violation of a municipal code or the state penal code. Okay, so it's entirely up to the prosecution to continue pursuing the case until the defendant is convicted. So they have discretion in terms of filing those charges, in terms of dismissing or withdrawing those charges, in terms of seeking a plea bargain in that case, and then in terms of what punishment they want. They'll argue for those things, although it's not necessarily going to be what they get. And prosecution can be done, and it is often done mostly by the district attorney, but it also can be done by the city attorney. So city attorneys prosecute municipal code violations, and then the city of Anaheim is unique in that it also prosecutes its own misdemeanors. Huntington Beach also prosecutes some of its misdemeanors. Okay, next are the courts. Okay, so once the prosecutor files a charge in court, the case proceeds through the superior court system. Judges rule on issues of law and arguments between the prosecution and the defense, which we'll get into in a second. The judge or jury will serve as trier of fact and decide guilt or innocence, assuming a plea bargain is not made before that happens. If the defendant decides to plead guilty or no contest to the charges, the judge is required in the state of California to advise generally that a plea of guilty can trigger immigration consequences for someone that's not a US citizen. Now next, the bubble in blue is the realm in which I operate, and that is the defense. So in the United States, in criminal cases, there is the right to counsel. It is private counsel if the defendant can afford it, and if they cannot afford a lawyer, then the court will appoint one for them. So indigent defendants can request court-appointed defense counsel, and they need to ask the judge for one. So defense counsel in the state of California are required to ascertain and defend against immigration consequences of certain convictions. And unlike the judge, they are required to advise with specificity on what those immigration consequences might be. It's not sufficient to say that just anything could potentially carry immigration consequences. You have to spell exactly what those things are going to be. Next slide. Okay, so now I'm going to give you the overview or the process in terms of the criminal and deportation pipeline. So basically, where does immigration enforcement overlap with the criminal process? Next slide. All right, so don't freak out. It's a lot, but the point of this is to give you a general overview. Hopefully the general overview will sink in, and then you can reference these materials or others later. Okay, so first, just generally kind of follow the little squiggly broken line from left to right, starting with law enforcement contact. And then from there, follow the rainbow. So red, orange, yellow, green, blue, purple. And then I decided pink was going to be the last color of the rainbow because I couldn't find indigo. So basically, we're starting with law enforcement contact. So that's, again, the police are in the field or the sheriffs are in the field, and they're responding to a complaint alleging a violation of law, and they're on the ground. They encounter someone that they believe to be the suspect. Okay, so they have some options at that point. Believe it or not, the cops actually have the option to let someone off with a warning. Police have a lot of discretion in terms of even saying that there's a violation or documenting it. So that's one thing to keep in mind when we talk specifically about policing and defunding the police. Okay, but if law enforcement decides that they really want to go after the suspect, they can do a number of other things. So like we mentioned earlier, they can cite and release that person. So basically giving them a ticket, although that ticket can often be much more serious than a traffic ticket. It can allege like a more serious violation of law. Okay, but basically it becomes on the other person to attend court by the date that's on the citation, all right? Or the person could be arrested and booked. So that means that they're actually placed in cuffs, they are brought to the jail, fingerprinted, photographed, and they are held for a certain amount of time. Okay, now that is very important because it is our first situation where there is contact with ICE. Basically, anyone booked into any jail in the United States, those fingerprints are automatically uploaded to the FBI database. And from there, ICE has access to those fingerprints. All law enforcement agencies in the United States have access to those fingerprints, including ICE. If there's any previous contact with ICE, it triggers a match, and that prompts ICE to transmit or send electronically a detainer request to the jail, okay, or a law enforcement agency, which I call LEA. However, in the state of California, that LEA can only respond to ICE if that person in custody has what's called a Trust Act exception. And I'll get into what the Trust Act exception is later, but they have to have experienced some kind of criminal justice consequence, usually a conviction, but sometimes getting very far along in the criminal proceeding on a felony case. Okay, so that's a Trust Act exception. All right, the next step is say the district attorney decides to file those charges once they get the information from the law enforcement agency. That's when the person is arraigned in criminal court. Okay, so arraignment means you get in front of the judge and the district attorney or city attorney, and then you have the opportunity to ask for a public defender. We'll get into the details in further slides. The next step in felony cases, so cases can be filed in order of infractions for municipal code or vehicle code violations, for example. They can be misdemeanors, which carry a maximum sentence of 364 days in jail, but are considered less serious. And then felonies, which can, the sentence can be minimal, but it can also be pretty high. It can go up to life or death. In the state of California, we still have the death penalty. Okay, but preliminary hearings in felony cases, and I'll explain in more detail what that is, can trigger Trust Act exceptions that allow that law enforcement agency that has custody of the defendant to contact ICE in response to that detainer. Okay, the next thing that can trigger a Trust Act exception is a conviction, and that can be for a misdemeanor or a felony. We'll get into which convictions later on in the presentation. Okay, and then keep in mind that at any point in criminal custody, the defendant is at risk of coming in contact with ICE. Even if a detainer is not issued, ICE can still ask the jail or prison to let them interview someone in custody. In the state of California, fortunately, all interview requests must be given to the inmate in writing. And the inmate can refuse to be interviewed under the Truth Act, which is different than the Trust Act. But the point is that we have some very good immigration sanctuary laws in the state of California that limit cooperation with ICE. Okay, lastly, at the point that someone is released from jail or prison, jail is where someone is held pending trial. Okay, it's somewhere that someone can be held on a misdemeanor sentence after trial. prison is where people go to serve lengthy felony sentences. Okay, so that's the distinction between jail and prison. All right, so basically the jail can only contact ICE to let ICE know about someone's released if they have a Trust Act exception. The jails are no longer allowed to continue to hold anyone past the completion of their sentence. ICE actually needs to show up to detain that person, or they lose their chance, and they have to find them through other means in the field. All right, next slide. Okay, so now the colors have gone away, and the red section is where the next slide is going to take us. So this is the cite and release phase. All right, next slide. Okay, so when we talk about cite and release, okay, so this is where someone is not arrested, okay, and booked into a jail. A law enforcement agency that comes across someone in the field or in the community that they suspect has committed a crime. I mean, just remember, the cops can always choose to not cite them and to just warn them. But should they choose to cite them, this is what the citation generally looks like. Redacted, of course, and then it generally shows like it has to show up to court on or before this date. Sometimes nothing happens on that court date, but sometimes the district attorney or the city attorney also sends another letter to the suspect to inform them that a complaint has been filed. So that means that they did decide to file charges in court based on the information provided by that law enforcement agency. And the letter is a reminder and notice to show up to court. Okay, so I do see a note here to not use the word inmate or something along those lines because we are talking about people. I am going to try my best to do that just so that to the extent that it's possible for the purposes of the presentation and to make it possible for people to identify who I'm speaking about. Okay, next slide. Okay, so I just dealt with the cite and release portion of, or option, I should say, and the next one is if someone is instead arrested and booked into custody. Next slide. So if someone is arrested and booked, the booking process basically is where the fingerprints are transmitted to the FBI, and then this is if ICE detects that this is a person that they have an interest in, they are going to transmit this particular document to that particular jail. Okay, so this is actually, Anaheim Police Department is pretty much one of the only departments that actually gives anyone the copy of the actual detainer. So this is basically what it looks like so that you all have an idea. But this particular person was actually released from Anaheim jail and was told to go to court on their own. But this is basically what the detainer looks like. And if the person is transferred from the jail to the county or another facility, the hold will follow them from there. Next slide. Okay, so just to give you an idea of where local police as opposed to the sheriffs operate, there are a lot of situations where many of you are trying to look for people in the very early stages of someone coming in contact with law enforcement. So they can be basically arrested by a police department or cited by a local police department, but they can also be arrested by the Orange County sheriffs themselves. So the sheriffs operate in areas that do not have their own police departments. You can find this map on the sheriff's website. It's primarily the more, I guess, if you want to call them outlying or rural areas, but it also covers small areas like Midway City. Next slide. All right, so so certain cities do have their own jails at their police departments. But if the Orange County Sheriffs arrest someone in the field, then they are going to hold them specifically at their own jail or jail facilities. And then anyone that is not released immediately after being arrested and booked by a police department, where they're headed to arraignment, is going to be transferred from the local jail to the Orange County Sheriff's custody. Okay, so basically, if you're trying to figure out where people are, the Orange County Sheriff's Department, unfortunately, has this thing on their website called literally "Who's in Jail." It has not changed at all after many, many years. That's still what it's called, but it allows you to find where someone is being held in custody. And this map, along with these not so lovely photos, describes basically the various facilities that people can be held in. Minors under the age of 18 are held at Juvenile Hall, which is in Orange, and nearby is the Theo Lacey facility, where people are held if they're considered maximum security risks. Take that for what you think it might be. I mean, really, it means to them the person is charged with a felony and they may or may not have some kind of history that to them, for whatever reason, justifies holding them in a more quote-unquote secure facility. Music, or the James A. Music facility, is a minimum security facility that they are currently converting to a quote-unquote mental health type facility, but do not be fooled. It's really just kind of trading one thing for another and being exactly the same. Okay, so, and then lastly, where most people are held is the Central Jail Complex in Santa Ana, which is closest to many of the courts. That basically, if you're looking for anyone in Central Men's or Central Women's jails, that's where it's at. And then the Intake and Release Center is also where many people are held, especially when they're awaiting arraignment. Next slide. All right, so, okay. All right, practically speaking, I feel it's important to figure out if someone's in custody, how do you find them? Like, how do you make sure they have basic things like access to phone calls and money on their accounts to buy basic things like shampoo and soap and things that you're basically deprived of, along with your dignity once you're booked into these facilities. So before I share this information, though, it's very important for everyone to note that all calls are visited. Even correspondence and visits with attorneys, we have to specifically ask them to turn off the monitoring equipment. Okay, so for anyone who is working with anyone in custody, please keep that in mind. It's very important that the cases not be discussed, because any of those statements can be used against that person in their court proceedings. We all want to help, but we all have to be aware that we can't trust law enforcement to do the right thing. Okay, so the first thing that you want to do is, if you're expecting a call from someone in custody, call your self-service provider to allow collect calls. Most likely, that's going to be the first and main way that someone is going to try to reach a loved one if they are arrested. Okay, so second, create a prepaid calling account through Global Tellink. I know it's gross. So Global Tellink is the phone provider for all Orange County facilities. It's much less expensive for you than taking a collect call from someone in custody. Definitely, like, if you're expecting a lot of calls from someone, the prepaid option is not a bad idea. Okay, next, there are instructions on the sheriff's website in terms of putting money on someone's commissary account. Believe it or not, nothing in jail is free, even though you're forced to stay there. And then also, it has the same instructions on how to post bail. Sadly, at this time, no in-person visits are allowed due to COVID-19. Otherwise, visiting days and hours are limited. Okay, so it's not only the visitation days and times, but also the number of visits and visitors. So it's really important that visitors, to the extent that they know each other, coordinate visits, okay? Because the worst thing is if you travel very far and wait very long, only to be told that that person in custody has met their limit in terms of the number of visitors. Okay, and recordings from phone calls, both video and audio, are routinely used against defendants in criminal cases. Just keep that in mind. Next slide. Okay, so I just dealt with arrested and booked. Next, okay, so arraignment in criminal courts. Okay, so next slide. All right, so in terms of what the courts will look like, these not so wonderful looking buildings, all from roughly the same period of time, are where court proceedings are held. Okay, currently, no members of the public are allowed in these facilities. I'll get into access in a little bit because public access to court proceedings is a right that's very important. But generally speaking, with arraignments, in spite of COVID-19, this is the division of cases in terms of how they're handled and why. Okay, so anyone that's in custody still at the time of their arraignment, so within 48 hours of being arrested, okay, if they are in custody, then arraignment is held at the Central Jail Department 1. So that's a courtroom that they built inside the central jail system. And pretty much everyone has their arraignment there, or their initial court hearing if they're in custody. Okay, so beyond that, for people who are out of custody, whether it's their initial hearing or their subsequent hearing after they've bailed out, those hearings are split up depending on the area where the crime is alleged to have happened. So first is the North Justice System. I won't read off all the cities, but the biggest city that the North Justice Center in Fullerton covers is Anaheim. The Central Justice System covers Santa Ana. Okay, and then the West Justice Center covers quite a few cities, but Garden Grove and Westminster are the ones that we work with most often. And then the Harbor Justice Center covers Irvine, and then all cities that are below or south of Irvine. So there used to be a South Justice Center as well for the South County area, but that court closed quite a while ago. So everyone goes to the Harbor Justice Center now. Next slide. Okay, so arraignment in court, believe it or not, court is still happening, and this is what it looks like. Basically, arraignment happens like this. Basically, the prosecutor is literally allowed to approach every defendant with an offer, okay? And that offer could be conveyed with some dishonesty. I mean, they could say, you know, this deal will go away if you ask for a lawyer. I've actually heard them say that before when they didn't realize I was a lawyer and they were saying it in front of me to people who are being accused of crimes. But it's important for everyone to know that that prosecutor has no obligation whatsoever to ascertain someone's immigration status or help them fight immigration consequences. It's really important to not speak with the prosecutor without an attorney, okay? Negotiating with the prosecutor often involves in pleading guilty or no contest in exchange for, say, no jail time if that person has never been charged with a crime before. And it is really scary. So that's why it's important for all of us as first responders to basically really be aware of that when we're supporting people. Even taking those offers from the DA could allow a law enforcement agency to contact ICE if it's a Trust Act exception, and it can make someone ineligible for immigration status or defenses to deportation. All right, it is important to know that once the prosecutor is made aware that there are immigration consequences that could potentially attach, they actually are obligated to consider immigration consequences in the plea bargaining process under Penal Code Section 1016.3b. Okay, I know there are going to be more numbers. You don't have to remember all the numbers. The general idea is important. It is almost always, though, the defendant and or the defense attorney that are the ones that make the prosecutor aware. Okay, so when the judge calls the person charged with the crime up, okay, that person being called a defendant, it's important that the defendant ask for an attorney. The public defender is automatically appointed for all people charged with crimes who cannot afford an attorney. The standard practice by the public defender's office is to enter a plea of not guilty, and then bail is argued and set. The next court date is also set. Okay, so those are a few things that generally happen in that initial arraignment. Okay, so, and at this time, because the public cannot attend hearings, only attorneys and witnesses who are giving live testimony are allowed in. It's important to note that you can still live stream all hearings through YouTube links on the court's website. All right, next slide. All right, so after arraignment, there are a lot of important things to know when working with defense attorneys, whether that's the public defender or someone else, which I'll get into in a little bit. But attorneys owe an absolute duty of confidentiality to their clients. And what that means is that no information regarding the representation or the case can be shared with anyone other than the client. That means family members, that means spouses. So it's an absolute duty of confidentiality. And it's really important that attorneys not do anything that breaks that, because then all of their communications with their client, including any statements that the client makes to the attorney, basically no longer is protected against the prosecution discovering it and using it against the client. All right. An attorney has to be the one to obtain consent directly from the client to share any additional information with anyone else. So that's really important to everyone that's a first responder here or a rapid response network member, because we all do our best to try to get information, but it's important to know what the limits are and what the client really needs to do. And when I say client, I mean the person charged with the crime who is also working with the attorney, okay, or represented by the attorney. So certain information can be shared with the express, written, and signed consent of the client. And although I know that a lot of people want to access that information, it is important to know that there are still times, even with that waiver, that attorneys, through basically state law, are not actually allowed to share everything. Okay. On the flip side of that, attorneys can and always should listen. So attorneys can receive any information that might be helpful to the defense, even if we ourselves as attorneys cannot share anything with someone who is not our client, right? Like my client, no one has done this. This is just a hypothetical. My client could be having a really bad day, but also be very serious and say that they've had it with their roommate and they have a plan to dispatch with their roommates, and they give me all of the details. I actually am not allowed to share any of that information with anyone else, even if I am convinced that that other party is in actual danger. Okay, so that's the extent to which the duty of confidentiality applies. And the client sharing information about the defense or what happened can also break that confidentiality if they aren't careful. Okay, so communication tip, if it's really important that other people be involved in the defense, make sure that the client of the attorney communicates with that attorney to provide that consent. Okay, it's not enough for an attorney to hear from the mother of the client or the spouse of the client that they have the client's consent. We as attorneys have to know that our client is comfortable and capable of understanding what rights they're giving up. Okay. Attorneys by their very nature are interesting people. I didn't make a lot of friends in law school. I'll just kind of put that out there. To the extent that you are struggling to communicate with an attorney, which believe me, I totally understand, keep communications with attorneys brief, clear, and to the point. If you're trying to leave a voicemail for an attorney, to basically be like, I have important information to share that will help with the defense. that's a really great way of leading with the message, okay, to get your point across to that attorney. All right, next slide. Okay, all right, some more stuff about working with the defense. Ultimately, like attorneys, the goal is to always flatten the perceived hierarchy between you and your client. But the reality is that situation is really difficult. So what I'm hoping to do here is to just explain certain rights that people have in their interactions with their defense attorney, and then also explain like who might be appointed and for why. All right, so the court automatically appoints the public defender in all cases where someone cannot afford an attorney. The public defender, though, might have to declare a conflict of interest and have either the alternate defender or the associate defender or conflict attorney represent the person instead. And the reason for that is you owe your client a duty of zealous advocacy, and that can be compromised in certain cases. For example, if there is a case with 5 people accused of committing a similar crime. Okay, so they are co-defendants. That's how they're described in the complaint. The public defender cannot represent all 5 of those people accused of the crime, because inevitably some of the defense will turn on certain people being more culpable than others, assuming there is like an issue that can't be resolved with regards to culpability. So, or there is a situation where the public defender is already representing a key witness against someone in a new crime or a new case, and the public defender can't reasonably expect to represent both people. But regardless, once an agency is assigned to represent that person in court, a specific defense attorney is assigned to defend that defendant for the rest of the case. Okay, the attorney will begin what's called an investigations process. Investigative staff are assigned to contact the person charged with the crime for the interview. Investigative staff also interview witnesses and other parties, including the complaining party against the client. The prosecution, so again, that's the city attorney, but more often the district attorney, are legally obligated to turn over the discovery to the defense at least 30 days before trial, or earlier if a judge determines that it's necessary to prepare the defense. That includes all relevant real evidence and any evidence that tends to show that the defendant might not be guilty, although the DA tends to not voluntarily provide most, if not even all of that. So it's often something that is fought over, but most commonly the rap sheet of the person being charged with the crime, the complaints, all the investigative reports, the body-worn camera footage, all of that is required to be handed over to the defense. Okay, so it is important to note that the defense is required to turn over certain parts of that discovery to the client at the client's request. Okay, so everyone who is charged with the crime and has a defense attorney, when that defense attorney is served with the discovery, the client has access to that discovery. It's technically their property, although the defense is required to withhold certain things like the addresses of witnesses. Okay, since 2016, the defense in the state of California is also legally obligated to ascertain the immigration status of their client, and with the client's consent, defend against those immigration consequences. Okay, so research is required, and for any client of the public defender or the alternate defender or the associate defender, I am the person in the office that they go to do that investigation. All right, prosecutors are generally not assigned to handle a case from start to finish, so that's why it's a little hard to hold them accountable. However, like I said earlier, they are required to consider immigration consequences in the plea bargaining process. So this is a typical point of entry for people in the Rapid Response Network. A packet of mitigating evidence is often sent by the defense to the prosecution as part of that request for immigration safer dispositions. It's important for us to know that our particular county's district attorney does not have a policy interpreting Penal Code Section 1016.3. certain other counties do, like Santa Clara, for example, has an excellent policy. So where am I going with this? Next slide. Our district attorney is elected. The district attorney is supposed to represent the people. Sorry, I laugh. It's just my coping mechanism for really horrible things. But basically, the prosecution's consideration of 1016.3 really depends on who is in office. So Todd Spitzer is just, they refuse to issue any interpretive policy on 1016.3 and what it actually means for their district attorneys. It's a little unclear to us as defense attorneys what they think it means as well, and when they will actually take it seriously. So the point of this is everybody that has the ability to vote, which is a huge privilege, just remember, you don't even have to vote for a prosecutor or a former prosecutor to become DA. Philadelphia and San Francisco, for example, elected public defenders to become their DAs. And as a result, we have much better policies, although I argue that they are never perfect as long as their goal remains generally what it is. All right, next slide. Okay, I realize it doesn't look like we got very far, but I promise we have gotten very far. We are at the preliminary hearing stage for felony cases. Next slide. Okay, so it's really important to remember that Trust Act exemptions, so that those things that basically allow law enforcement to turn people over to ICE in the state of California, you don't need a conviction for that if you're charged with a felony. Okay, so there is a stage in a felony case at which Trust Act exemptions can be applied. And that's the preliminary hearing when the prosecution calls law enforcement witnesses to establish that there's enough probable cause to move forward with the case to trial. Okay, so if a non-citizen defendant is held to answer at the end of that hearing to the felony charges by a judge, they will trigger Trust Act exemptions in certain circumstances. Okay, so the first one is a serious felony under penal code section. Okay, there are a lot of penal code sections you can read. I'm just gonna generally summarize them as serious, violent, and state prison felonies that are defined and listed out by statute. Okay, so strike offenses, for example. Getting held to answer on a strike, very bad now for immigration purposes. Okay, so examples of some of these crimes and these statutes are, someone gets held to answer on a felony charge of murder, criminal threats, which can literally just be you saying, I'm upset, I will hurt you, okay, in the heat of the moment. Robbery, that can be grabbing a bag of chips from a store clerk who doesn't want you to take it from their hands. Carjacking or first-degree burglary, that just means you entered a structure and you didn't know it was a house with someone in it. Okay, so those can all be Trust Act exemptions where the person might even be acquitted by a jury. All right, next slide. Okay, so that was the sad land of preliminary hearings. The next slide are convictions, also sad. Next slide. Okay, so convictions also can trigger Trust Act exemptions. There are a lot of them, and they require a very thorough reading of the statute. You all don't have to be experts in it. The Rapid Response Network is connected with a lot of attorneys that know this. But basically, generally, some of them are more obviously serious than others, okay? Some of them don't make a lot of sense. Generally, misdemeanor controlled substance convictions have serious consequences in terms of being able to get immigration status or get released from immigration custody, but misdemeanor drug offenses do not exempt you from the Trust Act. Okay, it's only felony controlled substance convictions or DUIs. It's also important to note that the California legislature unfortunately said that certain juvenile adjudications also count as convictions for the purpose of Trust Act exemptions. So being put through the juvenile justice system can also trigger Trust Act exemptions. And for the more aggressive counties that are very much into immigration enforcement, Unfortunately, the juvenile justice system does put our people at risk if the person is at least age 16 at the time of commission of the offense and is adjudicated to have committed an offense under the Welfare and Institutions Code, Section 707B. So that could be murder, robbery, assault likely to produce great bodily injury. Great bodily injury can mean a concussion. Robbery can again be like a store clerk has a bag of chips and doesn't want you to take it, and you take it, quote unquote, forcefully from their hands. All right, next slide. All right, okay, so if someone is convicted, sometimes it's a don't panic moment, but it's not good, generally speaking, but there are ways around it. Some of them require action immediately. Others require that a certain period of time be waited out. All right, so one thing that needs to kind of happen within 6 months of any plea agreement where someone is sentenced to probation is a motion to withdraw that plea for good cause. And that cause can include immigration consequences. The penal code sections are just a section of law in California that allows someone to do this. It is something that they have to argue against the DA's office or the office that got that conviction, and they do fight it very hard. Okay, so there are a few as soon as possible motions. If that judge failed to advise generally that a guilty plea could trigger immigration consequences, there's a motion to withdraw that plea. If the person is still serving a sentence, including probation, that's definitely the hardest post-conviction relief to win. They have to win a Sixth Amendment claim of ineffective assistance of counsel, specifically on immigration consequences. That's pretty tough. After a sentence, including probation, is completed, failure to meaningfully understand immigration consequences, there's a specific motion for that in California. People who have completed their sentence more than 10 years ago are eligible to file a certificate of rehabilitation with the court and get that granted, and that automatically sets them up to get a pardon from the governor. And those who are not within that 10 years can also file for a direct pardon from the governor. Obviously, those require a lot of equities, but these are excellent places for rapid response networks to help. Okay, so there are also standard post-conviction motions that might be helpful, like felony to misdemeanor reductions under 17B or Prop 47, or in the DACA context, expungement under 1203.4, just think of it as expungement. That can be helpful, or for really old drug convictions before 2011. Next slide. Okay, so we're moving from convictions to problems that could happen at any point in criminal custody. Next slide. Okay, so interviews by ICE can happen in immigration custody. They are kind of rare, but they could happen. Basically, in the state of California, if, you know, my guess is that in terms of how ICE gets tipped off, it could be a combination of the detainer being issued from the fingerprints, or it could honestly be sheriff's officials unlawfully sharing information with ICE and saying that they suspect someone without a hold to be in the country without authorization. So, but anyway, if ICE is going to interview someone now, they have to serve this form, which is a sheriff's form. They came up with it themselves. On that person in custody to make them aware that ICE wants to interview them, and then make it clear that they do not have to consent to speaking with an ICE officer, and they can and should always not consent to speak with an ICE officer. My experience is that people who have been in custody for a very long time have trouble asserting the right to say no, because cooperating with law enforcement is what has gotten them through the criminal justice system without significant abuse or you know, their life being put at risk. So for someone to say no is not, it could be easy for some people, but it's also important to note that we all have a role in helping them say no as well. And these are translated into, I believe, 7 other languages, but not all languages. Next slide. Okay, so if, sorry, all right, it's okay. All right, so if ICE decides to, or if the jail decides to notify ICE, they are also required to provide written notice to anyone that the person in custody wants them to be notified. So they can request an attorney be notified. They can request that another person be notified. It's very, very rare in my experience for anyone in custody to be aware of what this form is really telling them. Some people think that it means immigration attorney, and they don't check that box because they don't have an immigration attorney yet. But really, it's not very well defined in the statute, so it can definitely be your criminal defense attorney or your public defender, or even your family member. Next slide. Okay, so now we're moving from criminal custody to release from jail or prison, which should be a moment that everyone is able to celebrate. But at the end of the day, it puts people at significant risk, especially if there is a Trust Act exception. So basically, the jail or prison will notify ICE if that person is exempted from the Trust Act. And ICE has to show up to detain that person when they're released, or they find them later in the field. Next slide. Okay, so it's very important to know, though, that despite this law, the Trust Act, in the past, the Orange County sheriffs and corrections officers in the state of California would even interview people on their own, if they suspected them of not being US citizens. And historically, they were allowed to hold people on their release dates for an additional 48 hours to allow ICE to come and take custody. Juvenile probation in our county turned over more non-citizens to ICE than many other counties in their entirety. So we have a very deep history of collaboration between our law enforcement agencies and ICE, so we shouldn't trust that they necessarily are going to follow this law, and they might find ways and have found ways to go around this informally. Okay, it is important to know that 48-hour holds of criminal or people in custody are no longer allowed in the state of California. That forcibly ended Orange County's 287G cooperation agreement by operation of law, and the Orange County Sheriff's Department was not happy about it. Okay, so currently the Orange County Sheriffs and CDCR, so that's they run the prisons. A Trust Act screening is always conducted, and an email is sent to ICE with the date, time, and location of releases for people in their custody who are exempt from Trust Act protections. Okay, but we know that in practice, in every case where ICE has issued a detainer, but was not able to detain that person upon their release from the sheriffs, whether it was because they were protected by the Trust Act or ICE just simply didn't show up on time, ICE is following up on those cases and using information from other sources. One could potentially be probation, okay, but also others, to detain people at their homes or workplaces, even if they manage to evade ICE custody when they're released from the sheriffs. So let's keep that in mind as well. Next slide. Okay, so we're almost there to the end of the presentation. This is a very brief breakout session, but basically, Buddy is a lawful permanent resident. That means he has a green card, and he came to the US as a child. He never applied for naturalization, which is US citizenship, like the rest of his family, because he developed schizophrenia in his early 20s. He's estranged from his family and has several misdemeanor convictions already for possession of methamphetamine and some infractions for camping. That basically just means that you are unhoused and you are sleeping in parks or on the street. Okay, Buddy is arrested and charged with felony robbery after he is alleged to have grabbed a cell phone from someone's hand in a CVS parking lot and destroying it by throwing it on the pavement. Although Buddy is not a real person, I did pull this from a situation where someone decided to film a homeless person, and that person decided to just take the cell phone and throw it. Anyway, so Buddy is appointed a public defender whose investigators managed to track down his family to learn more about his immigration history. The family contacts the Rapid Response Network to ask for help defending Buddy. All right, so they have not talked to him in 5 years and don't know anything that's happened to him during this time. After missing several participatory defense meetings and some calls from the public defender, they share with one volunteer that they are torn between guilt and exhaustion because of how hard it has been to support Buddy. So 2 questions for the breakout groups. What is one statement of support that you'd like to give Buddy's family? Or if applicable, a story you can share about challenges of supporting a loved one through the criminal justice system. And then question 2, what are some interventions that OCRN can make at this time? And go.
I think maybe for the sake of time, maybe we can move into questions. Is that okay? Jacqueline, can you hear me? Jacqueline?
Okay, or not. All right.
Jacqueline, can you hear me? Let me.
Okay. All right, so we're kind of close to the end of the presentation time. Peacekeepers, do you think we should just kind of move through the break and skip the breakout session?
Hello. Yes.
Okay.
I think
Sorry.
Jacqueline, can you hear me?
Yes, I can hear you.
Oh, okay, sorry. Yes, I meant to say maybe we can just skip here and get to the end. And ask folks to maybe if they have questions just with the last couple of minutes that we have.
Yes, take a break in your heart.
I know it's been a lot of information for folks. We would ideally go into the immigration system and how sort of folks end up in immigration proceedings. Part of it is through the criminal justice system, as Jacqueline has just explained. Internal enforcement, which is, ICE coming to your house or workplace. As I mentioned, as Jacqueline mentioned earlier, 75% of all immigration arrests in our county originate from the criminal justice system, but internal enforcement is the other 25%, which is in-home arrests or, workplace arrests, or at the port of entry. If you are seeking asylum, they arrest you there, right? So, but maybe Annie Lai from the UCI Immigrant Rights Clinic will go over this system. So I just want to maybe check with folks that are interested in asking any questions now. Maybe if you put it in the chat, you're more than welcome to unmute yourself and ask Jacqueline any questions now.
Okay, so I do want to go through some of the questions that at least Peacekeeper Ivan pulled in terms of notables. So if I don't cover a question that was in the chat, I know we're trying our best to address everything. So very quickly, are there monthly quotas that might influence cops to make more arrest citations? It's entirely possible. I'm sure that certain kinds of arrests do figure into things like promotions, regardless of what quotas may or may not be there. Let's see, are there other passive points of information sharing, like the fingerprint database? What about, for example, where ICE can just look up that you're being released? So Orange County, in reaction to the Values Act, or SB 54 being passed in late 2017, did say that they would just go around it by posting all the release dates of people in their custody. That proved to be a much larger website issue than they thought it would be, and they were defeated by county IT bureaucracy. So, I mean, you can, if you are really diligent in refreshing the page under the list of people's names in custody, you might see that one of them changes from in custody to released, but in practice, it's nearly impossible to really detect, at least in our county, when someone is being released right then and there. All right, let me see. My scrolling skills are not so great, so I apologize if I miss anything. Are people in pretrial and post-conviction entitled to legal representation for habeas petitions for conditions other than prior representation? Are any hearings occurring in California in person or virtually? Okay, so it's a lot of questions, but okay, so basically anyone in pretrial or post-conviction, anyone in criminal proceedings generally is afforded the right to an attorney for the most part. or the public defender is allowed to also self-appoint. So if a public defender's office is contacted directly by someone who needs, say, post-conviction assistance, then we do regularly self-appoint on those. Like people from immigration detention do call my office, and I do self-appoint on post-conviction motions. Are any hearings occurring in California in person or virtually? There are quite a few hearings going on, although not all of them. So it's very county by county and case by case at this point, which is really kind of a disaster. And I'm sure it's going to lead to a lot of post-conviction options later on. But there are quite a few that are going on. So it really does help to check regularly with each county. Some information is provided on the court websites. Others can be obtained through public defender, even DA offices. Okay, I know, Buddy embodies a lot of my former clients. There are some comments about Buddy. Let me see if there's some additional questions. Okay, once fingerprints get uploaded to the FBI database, how would ICE know that this person is undocumented? That's a great question. Sometimes they don't. So sometimes they are wrong, which is why there is a lawsuit right now about those detainers. So yeah, I mean, basically, if the person has been detained by them before and has been deported, if it's happened recently, generally speaking, that gives them quite a bit of reason, if they have not granted that person immigration status, to have reason to believe that they're undocumented or can be put quite easily through the immigration enforcement process. If they've never granted the person status, that used to be a basis to issue the detainers as well, although the ACLU has successfully or is successfully litigating that case right now. It's the Gonzalez versus ICE case out of the Central District of California. So a mismatch with someone that has been granted immigration status by Homeland Security is no longer a good basis. The reason is they detained a US citizen who was born in the US and therefore never had any reason to give their fingerprints to Homeland Security, because why would you need Homeland Security to grant you immigration status? That's the gist of that case. Okay, let's see. Everyone, okay. I'm just trying to scroll through the questions. Okay, so I think this is the part where we open it up to more questions, if you haven't been able to ask yet.
I have maybe one quick question, or maybe if you can explain, Jacqueline, maybe like what are types of collaborations that we've had that have been fruitful in maybe stopping a detention or deportation, more specifically maybe as it relates to DACA?
Okay, for sure. So unfortunately, there are a lot of people who have DACA who do take those prosecutor offers before they're even appointed attorneys. I know that the Rapid Response Network often works with those people or people who are represented by the Public Defender's Office. Orange County is very aggressive in arresting people and charging them with DUIs. Unfortunately, for the purposes of DACA, that's a very unsafe plea. That's something that's going to cause someone to lose their DACA and put them at risk of deportation. It's one of the few areas in immigration law where there's that severe of a consequence for a DUI. So believe it or not, the Rapid Response Network was able to get like a congressional letter of recommendation for a client, which we gave to the DA as part of the mitigation packet. And the DA literally was like, maybe. I mean, it's really ridiculous. It's like, it's a congressional letter of recommendation. This person, awesome, in my district, please do not deport. So that just gives you an idea of how bad the situation is with the district attorney's office. But it took months and months of trying and trying and trying, speaking with different DAs, basically going to DA leadership, waiting out certain DAs because they rotate between cases, waiting out different judges in order to finally get a safe disposition negotiated. So that was a lot of work on the part of the Rapid Response Network. And on a personal level, client, very adorable, but also like really needed some help from people in the rapid response network to be assertive in those conversations with the public defender or even engage with them. So I think that even those like that's what people consider softer support actually goes a much longer way in helping someone defend themselves.
Thank you for that, Jacqueline. And for that particular story, they were able to get an immigration safe plea deal and were able to renew their DACA. So that was a very, it wasn't public, but it was definitely an internal victory that we were very happy about. So
Yes, and the public defender says it was all you all. It was all you all. That's like what he keeps saying. It's like they did everything. So I mean, it was it's just a really great example of how community can really rally around one person and help them get there.
so I think there's what are some examples of ways you can see people advocating for their own release and the release of others, both in criminal law and deportation proceedings. I think what's been helpful is like social bio packets and trying to show like the positive equities of people, and getting letters of support, you know, and trying to build up that network and push back on these elected officials who say that they can't do anything. It's like you can do a lot, you know, and it's hard because even some Democrats that I've engaged with that represent Orange County, you would think that they're a little bit more progressive, but I've gotten pushback from some of them that told me, I do not write letters of support for people in the criminal justice system, is like what he yelled at me over the phone. And I was like giving my nice white girl voice to kind of get a letter of support. So, you know, some of these folks that are in these offices are like aligned with like the, you know, I guess are like not necessarily pro cop, but they're just kind of sympathetic to the narratives of criminality that they just kind of like, well, you know, like justice will you know, just go through the system and you'll seek justice at the end. And as we know, like the system is corrupt. And so we need to do all of our efforts to bring back justice to this injustice system. Um, and there are a lot of people in this call here that are very good groups that you can connect with. Transforming Justice OC is a great countywide organization that is you know, holding law enforcement accountable. There's LEAN, the ACLU, the Orange County Rapid Response Network, you know, that are working really at these intersections. Very few criminal justice works. We need more. But please, you know, connect with those organizations, you know, for further support. Any closing thoughts, Jacqueline, before we close tonight?
No, but my only closing thought to add to what has been said is that when a case is filed against one of our community members in court, like it's always the people versus name of community member. And it's important for the quote unquote people to remember that we are actually the people and that we all have a voice in terms of what happens to this community member. And thank you to everyone in this group, whether it's even like holding me accountable or making sure I don't use like office language, you know, and addressing people in our community, and everyone who came here today to come together. I think that it's like such a huge start and that people do have a lot of power, and whether it's to transform a life by showing that person how valued and worthy they are when they've been treated so poorly by the system, or whether it's showing the system whose voice and opinion really matters. And like whoever you are, regardless of your role, you don't have to. The main thing is people ask me like on a personal level, like, should I go to law school? And I'm just like, no. But I mean, it's like, it's just one of those things where there are so many other ways to influence someone's life. And there are times that as an attorney, I feel limited in what I can do. And it's definitely a group effort whenever I work with the Rapid Response Network to like actually make a difference in someone's life.
Great, thank you. I think folks are interested in the buddy situation or scenario. Jacqueline, I don't know if you have time to go over that, or would you prefer folks email you? I'm open to
Um,
much.
sure. Well, the actual buddy is still fighting their case. I mean, it's a horrible case where they were videotaped by someone and they grabbed the phone, like, and they were charged with robbery. We are getting there. Fortunately, like in reality, like I was alerted to it rather early on, and because Buddy had already been through removal proceedings and had been granted cancellation of removal already, he can't be granted relief a second time. So it's very important that Buddy in this case like actually avoid any contact with ICE whatsoever.
Great. And I think if there's any other questions, here's Jacqueline's email. Feel free to, reach out to the Orange County Rapid Response Network if you have a loved one, that is a non-citizen, DACA recipient, undocumented, documented, asylum seeker, all of these, that are going through the criminal justice system. Participatory defense has been very fruitful in having to support community members and to give community members that agency back, and to feel empowered to take action. Most of these systems, as you know, isolate folks and silo folks and makes folks feel like they're alone. But there's a group, and there are groups in Orange County that are stepping up to kind of support. So reach out to the Orange County Rapid Response Network. Continue to attend these trainings. Next week, we're going to be focusing on art as activism and incorporating art in our movement. So William from Anaheim will be joining us. So thank you all so much for joining today, and we'll see you all next week. Thank you, Jacqueline. And there's so much appreciation for you on the chat and for everyone on the
Thank you everyone for being here. Be my first.